private member and lawfully processed and passed by the House. The question that arises is, could a private member lawfully bring a bill for the amendment of the Constitution? To answer that question, we refer, my lords, to Article 94, Clause 4B of the Constitution. This article guarantees the right of a private member to bring a private member's bill. When he does so, Article 94, Clause 4C commands the Department of Government, whose area of operation is affected by the bill, to afford the private member reasonable assistance in processing the bill. Rule 121 of the Rules of Procedure of Parliament provides for the procedure of processing the private member's bill. Under Rule 121, Sub-Rule 1, the private member begins the process by introducing his bill by way of motion to bring a private member's bill. Under Rule 121, Sub-Rule 2, when the motion is carried, the Clerk of Parliament is obliged to print and gazette the bill. Under Rule 121.3, when the bill has been published in the Gazette, the process of the bill shall be the same as followed in respect to the government bill. It therefore follows that once Honorable Raphael Majez got leave to present the bill under Rule 121.1 and the bill was gazetted, it took exactly the same course as all other bills presented by government.
So, Mr. Deputy Attorney General, is that really not a side issue? Because you started off by saying the issue is whether the bill offended Article 93 of the Constitution.
Yes, my Lord. That is exactly where I'm going, my Lord.
But it's not questioning whether a private member may or may not move a bill. It's not questioning that at all. It's a question whether the private member's bill, because there is a prohibition on Parliament not proceeding on a bill which imposes a charge unless it is moved on behalf of government. So that's the issue.
That is exactly where I'm going.
Please get there.
My Lord, I'm saying the majority of the land justice of the Constitutional Court who address themselves this matter found as the fact that the original bill introduced by Raphael Majez was, as affirmed by the evidence of Janet Chilibwe, Clerk of Parliament, and Keith Mackenzie, accompanied by a certificate of financial implications that stated that the bill was budget neutral and did not offend the provisions of Article 93 of the Constitution. My Lords, I refer you to the judgments of Justice Remy Kassoye, page 241, paragraph 1130. It is contained in volume 4 of the Record of Appeal of Mr. Mabilizi. Then the judgment of Cheborwin Marshachi, page 631, still in volume 4 of the Record of Appeal of Mabilizi. And Justice Busoke, at page 707, volume 4 again. It is our submission, therefore, and we make this on page 4 of our response, of our written response, Constitutional Appeal number 4, that having ruled that the original Majez bill complied with Article 93, they went ahead, straight up sections 2, 5, 6, 8, and 9 and 10 of the Act for, among other reasons, failure to observe the provision of Article 93. They upheld sections 1, 3, 5, and 7, which in their considered judgment complied with Article 93. We agree with their lordships, and we invite this honorable court to uphold the judgment. In conclusion, our submission is that the original bill brought by Majez did not, on the face of it, make provision for a charge on the consolidated fund.
How does it mean on the face of it? You mean underneath it may happen?
But
I think
you have to be categorical.
I want to
did it or did it not impose a charge?
It did not, and I want to take my rose to the wording of Article 93 of the Constitution. Article 93 is clear and unambiguous. It says Parliament shall not, unless the bill or motion is introduced on behalf of government, proceed upon a bill, including an amendment bill, that makes provision. Those are the key words. The bill that makes provision for any of the following. And when we go to A2, the imposition of a charge on the consolidated fund or other public fund of Uganda, or the alteration of any charge or otherwise by reduction. Now, our submission is that to determine whether a bill makes a charge, makes provision for the charge, you look at the bill.
Yes.
You look at the sections. Does any section make provision for a charge on the consolidated fund? Our submission is that the original Majelis bill, looking at the various sections of the bill, did not create a charge on the consolidated fund.
How about the amendments?
My Lord, that's why I was saying that the lordships found that the amendments of Tusime, of Nana Ramafabi, which were brought on the floor, apart from other reasons they raised, created charges on the consolidated fund, and they rightly struck them off. And we are not complaining.
Yeah, but the question was separate. The particular talking of the bill. You have not addressed the question of severance.
Yes, my lords, I am addressing the process. The issue of severance will be separately addressed by the Land Solicitor General.
Now, my question then is, the original bill, as you call it, has no provision for creating a charge.
On the consolidated fund.
In the course of debating it, amendments are moved which create charge in the consolidated fund.
Yes, my lord.
Reading Article 93, Parliament could not proceed on that bill. Once amendments were introduced, because it says a bill or amendments. Read 93. What of it?
Parliament shall not address the bill or motion is introduced on behalf of the government. Now,
first read all of it.
Proceed upon a bill, including an amendment bill. An amendment bill.
Yes, but this was not even an amendment bill. You are actually amending the same bill. It's the same bill which was before Parliament.
Yes,
the moment an amendment was introduced, which had, you say yourself, had implications of charging the consolidated fund. Could Parliament proceed on that bill?
My Lord, that's where we shall be submitting that the judges of the Constitutional Court rightly decided to sever. They looked at the original amendment. They saw that the amendment, the original bill, they saw that the original bill didn't offend the provisions of Article 93. However, the amendments which came on the floor in their judgment offended the provisions of Article 93. They decided to sever.
It may be a fine point, Mr. Deputy Attorney General. It is not the problem of the bill being severed or offending. It is whether the Parliament of Uganda could proceed on that bill.
My Lord, the answer to that is that Parliament had already proceeded on the bill.
The moment the amendment was brought, could the Speaker allow Parliament to proceed?
Then at that moment, you look at what was brought in amendment. Parliament had already rightly proceeded on a bill which complied with the provisions of Article 93. In the middle, they brought an amendment to the bill. When Parliament had already proceeded,
it was not a different bill. It is the same bill. And there is an absolute prohibition, which you have just read out.
Why did they proceed?
And what was passed?
You see, as I said earlier, Parliament had already proceeded on a bill. And rightly so.
When does proceeding end?
Proceeding? It ends when the bill is concluded.
Yes.
My lords,
including consideration of illegalities?
Yeah, that is why we say, from our side, we agree with their lordships that it was wrong for Parliament to proceed on the amendments.
No, on the bill.
No, not on the bill. On the amendment.
It was an amendment.
My point is, Parliament had already proceeded. Now, in the
No.
somebody brings an amendment.
Honorable Attorney General, please. You've just read something there. You have said there is a prohibition. Parliament cannot proceed on a bill which creates a charge on the consolidated fund by way of addition to make it complete. What you have said is there was no amendment bill. There was a motion to amend the same bill which had implications for the consolidated fund. The question really which you should answer very quickly is whether the action of the Parliament to proceed on that amendment at that time was constitutional.
My lords, that's why I'm answering that at that stage the amendment to the bill was brought. Parliament should not have proceeded on the amendment.
It was unconstitutional for Parliament to proceed.
To proceed on those aspects that contravened Article 93. And that's why we entirely agree with their lordships when they said those provisions which came on the floor of the House shouldn't have been proceeded upon because they offended Article 93 of the Constitution. And that's why we agree with them that they rightly struck them off.
Yesterday, Mr. Ogalo, I think, pointed out that somebody, maybe even you, did point out to the Parliament that proceeding on that bill would be unconstitutional, and they ignored you or ignored whoever raised it.
My lords, that was a different matter.
Okay.
It touched, it was a different matter. It touched the articles which were entrenched. When Honorable Nanda Ramafani attempted to amend an entrenched provision, that's when Honorable Mwesi Barkuta raised that objection. My lords, as I was saying, the imposition must be apparent on the face of the bill. That is in some of its provisions. We invite your lordships therefore.
What do you say to Honorable Lukwago's argument concerning the 29 million shillings? There's a contention by Mr. Lukwago.
I was continuing, my lords.
Okay.
I was saying the imposition must be apparent on the face of the bill. That is in some of its provisions. This article, to answer your question, my lord, does not concern itself with expenses relating to the processing of the bill, like the cost of printing, gazetting, saturating, consultations like the 29 million, or implementation. Those are effects. But you look at the face of the bill, you look at the sections or clauses of the bill, and you see if any of them imposes a charge or makes provision for imposition of a charge on the consolidated fund. So those expenses of 29 million shillings to facilitate members to do consultation were not anticipated under Article 93 of the Constitution. Reasons therefore, we invite your lordships to note to uphold the decision of the Justice of the Constitutional Court that the original Majesty Bill which was proceeded upon did not in any way infringe the provisions of Article 93, and to uphold the decision, strike off the sections of the bill which were brought on the floor by way of amendment for having been unconstitutional and in breach of Article 93.
Well, we hope that when the Solicitor General will answer, because I thought when he says don't proceed, you halt. That's what it means. Stop wherever you are.
All those very ones
on the bill.
So only the amendments.
If you are traveling to Kampala, they say if you reach where such a thing happens, don't proceed to Kampala until you come back. Stop. Don't proceed.
Our submission is that Parliament ought to not have proceeded the moment the amendments were moved.
But then they proceeded.
They had already proceeded.
And what is the effect?
The effect, my lord, is that the offending...
The way you are defining proceed is rather very restrictive, one. But two, from the perspective of the parliament, what bill was sent to the president? Because when the bill was sent to the president, was it sent in form of different provisions, or was it sent as one document? Because once we start saying you don't proceed on those provisions, and we actually insinuating that we deal with provision by provision rather than with a one complete entire document.
My lord, I'm seeking your indulgence. I intend to respond to that aspect when I reach the 14 of the certificate of compliance, because I will demonstrate that what the Speaker sent to the President was the bill as it contained the original provisions of the Majesty's bill, excluding the items that were amended, they were moved for amendment on the floor. I'll be addressing that point. My lords, that takes me to querying the suspension of Rule 201, Sub-Rule 2 by Parliament. My lords, this is the rule that requires a 3-day period between laying on the table of a report of a committee on a bill.
What are the rules?
201 Sub-Rule 2. As we note, my lords, that is the rule that requires a 3-day period between laying on the table of the report of a committee on a bill and its debate. It is in evidence, and the hazard will show, that before the debate, the motion to suspend that rule was moved, seconded, and vigorously debated and passed. My lord, it has been contended that that motion to suspend the rule was not seconded. On secondment of the motion, I wish to invite my lordships to the affidavit of Jenny Chiburike, additional aspect, paragraph 29, which is contained on page 320 of the Uganda Law Society Record of Appeal, which is volume 1. In that paragraph of Jenny Chiburike's affidavit, paragraph 29, she clearly avers that the motion to suspend the rules was seconded by Honorable Varieku, MP Jinga Municipality, Jackson Kafuzi, MP Chaka County, Doreen Namule, woman MP Amulata, Isaac Musumba, MP Uzaya. That is the evidence of Jenny Chiburike, and it is our submission that that evidence was not controverted. So, the motion was moved, it was seconded, it was vigorously debated.
Controverted how?
It was not challenged.
Do we have the answer? Do I need anybody to tell me that there was a secondment? I look at the answer.
Yes, my lord.
Yeah.
When you look at the answer and all the pleadings of the evidence.
The point I'm making is that I don't need anybody to controvert it.
Much obliged, my lord. So, the motion having been raised and passed, Parliament had the power to suspend that rule and proceed with the proceedings.
But I think what has been an issue from reading your pleadings and submissions is not so much whether the motion was seconded. It is the purpose for the application to suspend. Why was the rule suspended? Because the justification seems to be that because people had already had the report on their iPads, Is that the purpose of Rule 2?
I intended to invite your lordships to uphold the finding of the Constitutional Court, especially Justice Warshachi, on page 95 of the Record of Proceedings, and the Deputy Chief Justice on page 176, who agreed that the rationale of the rule was to give ample notice to of the contents of the committee report to members of Parliament, to enable them to prepare for the debates, and that the purpose was achieved because by the time the rule was suspended, members of Parliament had received the report on their iPads 4 days before the debating.
And you agree with that?
And we agree with that.
But before you agree with that, isn't it a matter of parliamentary practice that when a matter is required to be laid on the table, the purpose is that now this becomes the property of Parliament?
My lords, that is the rule.
Wait a minute. There is a distinction between a matter being laid on the table for it to become now officially a document or a matter of Parliament, and the same thing being communicated to individual members. What you are talking and what the justices are talking about is the information reaching individual members. But was this ever deposited, laid on the table of Parliament for it to be a document of Parliament? This is with the purpose of Rule 201.
Yes, first of all, I want to say that it was true that the report was laid on the table. However, even before laying on the table, the report was saturated on the iPads of the members of Parliament. Laid on the table, as my Lord rightly observes, is for purposes of the document becoming property of Parliament so that every member can access it. It is the same intention as saturating it. When you saturate it on members' iPads, then all members get it, and they treat it the way they want to treat it, as if it was the property of the House.
See, the whole thing that runs through, because we have power to do it, we do it. Parliament has power to do it, we do it. But really, a very important bill like a constitutional amendment was taking the arguments which you need to answer. What did it cost the mover of the bill or Parliament to respect this rule, which says debate on a report of a committee on a bill shall take place at least 3 days after it has been laid on the table by the chairperson or deputy chairperson or a member nominated by the committee of the Parliament. This is the rule, made for Parliament, for orderly debate of bills. Lay it on the table. People have not solved it. The country has not solved it. Members may access it. It's now the property of the House. Give it 3 days and debate. But you seem to be saying because Parliament has power to change it, so we change it and debate within an hour.
My lords, it all goes back to the intention of that rule.
Well, but it also goes about the procedures, because the question is the legitimacy and so on of the procedures adopted. You really must address that, Mr. Attorney General.
My Lord, you already pointed out that the reason behind that rule was to ensure that the document becomes property of the House so that members can access it, look at it, and prepare themselves for debate. If that was the purpose, and I already agree that that was the purpose, if you put it online, and by the way, we passed the Electronic Media Act, which provides that the document communicated by electronic means is as good as the one communicated in the hard copy. So, based on that law, my Lord,
so this has been incorporated into the rules of Parliament now?
Yeah, it's a law of general application.
Okay, fine.
It also applies to Parliament.
But the intention of applying the law so is important. If you take it.
Honorable Mr. Putan, I think you have not answered what the Chief Justice asked about the. I mean, there is the spirit behind the actions that you take. For example, the need to remove the requirement of giving members extra days after the report has been laid on the table. I think you need to tell court that it was so urgent. The bill was so urgent, it was in national interest that the matter be attended to as quickly as possible. That is the point I think that you need to talk about.
My lords, the evidence in the answered and in the record will show that there had been a lot of time squandering by members of parliament trying to oppose the introduction of the bill. Parliament had eaten into its time allotted for the enactment of that bill, and it had become so urgent that the bill be handled without further delay. And since the rule was there, allowing us to proceed immediately, to suspend the other requirement and proceed immediately, because of the urgency of the matter, it was seen fit. In any event, these rules of procedure were not acted in vain.
Yes, they were not acted in vain, but you are now beginning to worry me. Because you started by proceeding when we were discussing the issue of Article 93, how the bill started very well without offending the Constitution,
Yes,
but somewhere along the way, amendments were introduced which offended the Constitution. Now you are saying, in part of debating that it had been done in a hurry, we had to suspend bills. Now I'm wondering whether those mistakes that were made and you ended up discussing and passing unconstitutional things were because of the hurry with which you are dealing with the bill.
No, my lord. Once the
Well, you have to
bill,
disabuse me of that because that was your argument.
once the bill was tabled for debate, the debate took a normal, orderly, and proper way.
Including suspension of the rule.
That was the procedural aspect which was carried before, which is allowed by our rules of procedure. There was nothing irregular about it. If this rule was to be protected, it would have been included among the rules which under Rule 16.2 could not be suspended. So my submission, my lords, is that Parliament acted properly by allowing the suspension of the rule. My lords, I now go to suspension of members of Parliament. I want to refer, my lords, to pages 9 to 11 of our written response to Constitutional Appeal number 2 by Madam Abilizi. I want to adopt our submissions and emphasize that Rule 7 of the Rules of Procedure of Parliament provide for the general power of the Speaker to preserve order and decorum in the House. Rule 79.2 empower the Speaker to order any member whose conduct is grossly disorderly to withdraw from the House. Rule 82, Sub-Rule 2, empowers the Speaker, if she or he considers that a conduct of a member cannot be adequately dealt with under Rule 77.2, to name and suspend the member for a period stipulated in Rule 88.4. Under Rule 89 of the Rules of Procedure, a member so suspended is obliged to immediately withdraw from the precincts of the House. My lords, apparent member is apparently misconstrues Rule 88.4, which stipulates the period of suspension and the manner of computation of the days of suspension. The usage of the word excluding in that rule has been misconstrued by Mr. Mabilizi to mean that a member remains in the House on the day he is suspended and the suspension will resume the following day. Such an interpretation, my lords, would be absurd. In any event, such an interpretation would contradict the provisions of Rule 89, which say the member suspended shall withdraw from the House immediately. The word 3 days excluding the day of the sitting would mean that when you are quantifying, when you are calculating days, you don't include the day on which the member has been suspended. The suspension takes immediate effect.
Before you leave that point of suspension, we may have, I may have no issues about what the Speaker did and whatever powers she had. But how about how that process was managed after the Speaker had made her pronouncement? Because she disowned the process after. No, the complaint is that after the Speaker had performed her function, Parliament was invaded. And the Speaker has raised an issue about that invasion, and it seems I haven't seen any evidence of anybody responding. Just a moment, responding to that, what she calls, I think she calls strangers. Now, I just want you to take specifically to Article 137. 137. 3B. In terms of that article, how would you describe what happened? Would you say it was in accordance with this Constitution, the process which the Speaker disowned? Because we are supposed to make a declaration on that act. You know, this Constitution has act with the big A and act with the small a. Now that act, which the Speaker says, I don't know where these people came from that came and arrested people, those who were on the list, those who were not on the list, people taken to prison. How would you describe that one? Would you say it is in compliance with this Constitution?
My Lord, the chronology of events, as ascertained from the answer,
yes,
will show that Parliament sat in the morning, and because of what had transpired the previous day, the Speaker says, because of the parliamentary conduct of the members, I will name and suspend the following members.
Fine.
And she said, Parliament is suspended until the afternoon for the members to withdraw from the House.
Fine.
Now, after suspending Parliament, to allow the members to vacate,
yes,
the members refused to vacate.
Now, who determines the refusal to vacate?
The sergeant,
I thought the Speaker.
Actually, the Speaker,
the Speaker is the one
directed that the Sergeant of Arms should ensure that members vacate. It is our submission, and we made it in before the Constitutional Court judges, that the Sergeant of Arms is not an individual, it's an institution. So once it is overpowered, it has the right to call upon extra force to ensure that the orders of the Speaker are respected.
And I thought that's what the Speaker would be taught when she raises issues about it.
The Speaker raising issues?
Yes. She raises issues about what happened following her suspension of the members. The letter.
My Lords, the details of that issue will be handled under violence. We have somebody separate to handle violence.
No, but I think still on procedure, that suspension. When I have no quarrel with the powers of the Speaker to suspend members and so on.
Yes,
when she suspended the House and walked out, was Parliament now sitting?
My Lords,
was the House in session?
Our submission is that a sitting of Parliament is continuous.
Yes, but when
Parliament is suspended, the sitting continues.
Yeah.
The sitting only terminates when the House is adjourned.
Let me make myself clear. As presiding officer over this court, I have powers to order that you be removed from this court.
Yes, sir.
So if I say I am now adjourning this for 10 minutes to enable you to go out. Right? So court is not sitting. Would court be sitting when I've adjourned?
Because my lord, you have said I am adjourning.
I am adjourning.
Yes, ma'am.
Right? Or I am suspending.
Or I'm standing over the public.
The two my lords are not the same.
No, wait a minute. When I am out, court is not sitting. People come and remove you. Before I have ascertained that you disobeyed my order, someone comes and removes you when the court is not sitting. In this case, let's use your word, the speaker suspended the house. She had not yet come back to ascertain that these people refused to go out. When people come out and remove them, is that the chronology of events? Maybe I'm wrong.
My lord, as I said, the chronology of events was, the speaker says these members are named and suspended. They should vacate the house. And the sergeant at arms should ensure that they move. And she suspends the sitting, not adjourns.
Okay,
in parliamentary practice.
He suspends the sitting.
In parliamentary practice, there is a difference between suspending the sitting and adjourning. When we suspend the sitting is deemed to be continuing. But
when you suspend it, it is deemed to be continuing.
Yes, my lord. That is my submission.
So what was continuing then without the speaker?
The sitting of parliament is a continuous process until parliament is adjourned.
But parliament does suspend or adjourn for break, for tea, for lunch. They do, don't they?
My lord, technically the two terminologies are different.
Okay. So adjournment. So parliament was sitting.
Yes, my lord.
At that time.
Yes, my lord.
Without the speaker.
That's our contention.
Without the speaker.
Yes, my lord.
Because I thought when the speaker, when the Honorable Kutan, Honorable Deputy AG, I'm asking a question.
My lord,
when the speaker goes out, doesn't the mess get removed? Does the mess stay there when the speaker is not sitting? When the speaker is not in the chair, does the mess stay there even for 5 minutes?
My lord, that now clarifies the matter. When parliament is suspended, the mess remains. It's not taken away, implying that parliament is still sitting. When parliament is adjourned, the mess is taken away. So it's our submission that even when parliament has been suspended, the sitting is continuing. My lords, I invite you to the definition of sitting in our rules of procedure. And it says sitting means a period during which
Where is it?
parliamentary rules of procedure, rule 2, interpretation, on page 7 of our rules of procedure. Sitting means a period during which parliament is sitting continuously without adjournment, and includes any period during which it is in a committee. So, in addition to
does that answer our question?
The question is
the question which my lord, my brother Musa was asking. The speaker suspends the house and moves out. According to you, the mess stays there. The sergeant at arms is in charge.
Yes,
without authority of the speaker, the sergeant at arms is in charge. People come in and take away members of parliament and whatever followed. The speaker now says, I don't know who are those people. Why couldn't the speaker just call the sergeant at arms and say, who are these people who did this, so that the sergeant at arms says, I did it? Why did it come an issue?
The chronology of events was that the speaker first asked the members to move out. The members refused. She shouted again, please move out. The members refused.
No, the speaker doesn't shout.
She called upon them to move out. They refused. Then she directs the sergeant at arms to ensure that the suspension is effected by removing the members. And in order to allow the sergeant at arms to do his work, he suspends the sitting. Not adjourns, he suspends the sitting to enable the sergeant at arms to do his work. And the sergeant at arms find that he has no alternative.
I understand that. My question, which I believe is an issue because we have seen this letter of the Speaker on the pleading. The sergeant at arms would naturally, and I believe logically, be expected to report to the Speaker that now the House is cleared of the people. I have done my job.
Yes, my lord.
Why would the Speaker then be writing to the President to inquire how people were removed from her house?
Well, because there was, I think the Speaker didn't consult with us, we would have advised us.
No, she didn't have to consult with you. The person she had left in charge was the sergeant at arms.
Yes,
and you clearly said that the sergeant at arms is an institution. That's the institution that would have reported back to the Speaker. So I'm asking, if these things were going constitutionally according to procedure, how would the Speaker then be writing to the President for an explanation as to who had come into our house?
If you don't know, say I don't know.
Because at that level, once the sergeant at arms is not empowered, it becomes a security issue. It is the security of the sergeant at arms to determine what force he needs to implement the Speaker's directive. At that level and at that time, the Speaker may not have known what was required in security terms to remove the errant members.
Proceed. Actually, I think you just 10 minutes.
10 minutes. My Lord, I now address the alleged delay of the bill in the committee beyond the stipulated 45 days, allegedly contrary to Rule 128, Sub-Rule 2 of the Rules of Procedure of Parliament. My Lord, it is important to note from the outset that the appellant did not specifically plead this issue in his petition, but only brought it up in an affidavit in rejoinder. This explains why we did not respond to it. It was in his affidavit in rejoinder to the affidavit of Jen Chivirige that Mr. Marema submitted that the report of the Legal and Parliamentary Committee was not valid since it had delayed in the committee beyond the 45 days, contrary to Rule 128, Sub-Rule 2, and 1/4 of the Rules of Procedure of Parliament. My Lords, Rule 128 provides that whenever a bill is read the first time in the House, it shall be referred to the appropriate committee for consideration, and the committee shall report to the above House within 45 days. Rule 1/4, Sub-Rule 1, provides that no bill shall be in the committee for more than 45 days. Rule 142 provides that if a committee finds itself unable to proceed at complete consideration of any bill referred to it, the committee may seek extra time from Parliament. But the basis of Mr. Maru's argument is that since the bill was referred to the committee on 3rd October, the 45 days would run out on 17 September 2017. Yet, the committee reported to the House on 14th December after the expiry of 45 days. We wish to point out that had this matter been raised in time, we would have read evidence to prove that the committee acted well within the provisions of Rule 128 and 140 of the Rules of Procedure of Parliament, in that whereas the bill was referred to the committee on 3rd October 2017, the House was sent on recess on 4th October. During recess, no parliamentary business is transacted without leave of the Speaker. Therefore, the days could not start running until leave was obtained. Had we had the opportunity, we would have produced evidence to show that by letter dated 29th October, the committee chairperson did apply for leave, and the leave was granted on the 3rd of November. The 45 days, therefore, started running from the 3rd of November 2017. That means they would expire on 16th December 2017. And the committee reported on 14th, which was 2 days before the expiry of the 45 days. So our submission is that there was no breach of the mandatory requirement that there would be in the committee for 45 days.
Deputy Attorney General, looking at what we have after your submissions, actually what you are doing is reading word by word. I think you would use your time better if you just highlighted.
Much obliged, my lords.
Otherwise you won't have the time.
Much obliged, my lords. What I'm doing, my lords, with the other issues, like members crossing the floor, the allegation is that the members unlawfully cross the floor. We want to reiterate our submissions and invite
You have 5 minutes.
and invite your lordship to find that there was no breach of the rules. The same applies to inability to close the doors and draw the bar. The speaker explained why she did not do that. She had justification. It was not practically possible, given the numbers and given the fact that, as of now, some members of parliament followed debates in the gallery, so she could not close the doors and lock out those members. And the land justices found that the speaker acted properly. On lack of consultation and participation of the public, I invite my lords to uphold our written submissions and the decisions of the lordships, and find that there was sufficient consultation of both the public and the committee duly carried out its consultations and involved people in.
On that issue of consultation, what do we do with the letter of the Inspector General of Police? But let me explain my point so that we will explain. The Speaker releases MPs to go and consult. And somebody, Inspector General of Police, decides on what form of consultation, where to go and not where to go. Again, in terms of Article 137, 3B, where do you place that Inspector General of Police letter? Where he says you don't go elsewhere.
And I think you could link that to the issue which you actually submitted on. That in Uganda, there are no guidelines or law, which must be followed for purposes of participation or consultation. So the Speaker actually releases members of Parliament. My assumption is that it was up to them to determine the strategy or method of consultation to enable the public to participate. So what was the effect on the sufficiency of participation of consultation in light of the fact that Asman issue, or maybe I shouldn't even go to sufficiency because that then brings in the substantial role. But we must remember that rights are given to individuals, and each individual has a right to participate really.
My lords, on that issue, the lordships in the Constitutional Court found that directive, the order of the Inspector General of Police, was unconstitutional. That's why we never cross appeal that.
So what's the effect of that unconstitutionality?
Now, I'm proceeding, my lords. Nevertheless, there is evidence on record and in the Hansard that movement in their debates testified that they had crisscrossed the country. They had consulted from north to south from active consultations.
I'm not very sure that we can even go there. You make a declaration under Article 137 that this act, small a, of the Inspector General of Police, you are saying we declare it unconstitutional.
The lordships found that, notwithstanding that unconstitutional
that one we shall go there when we are considering.
Factually,
we don't know whether we can cross there.
My Lord, I am persuading you to cross there.
The one who is going to argue that point of substantiality, maybe we'll consider
My Lord, that's
that
what
we can go beyond the declaration.
My Lord,
Because that's what
that's not my
that's
submission.
why I'm referring to Article 137.
Notwithstanding its existence, did not in fact affect the process. The consultations went ahead. In other words, the directive was not complied with. And constitution.
Nobody was prevented from consulting. Is that what you are saying?
Yes, my Lord, nobody was prevented.
Things are saying except.
And the account would be that we consulted, but within limits, which actually is the thing that took place. We consulted,
Please,
but we are
don't wind up. We have eaten into our time.
My Lord, on failure to separate the second and third readings of the bill by 14 sittings of that require a referendum, and Article 261, which refers to between the reading of the second and third reading of the bill, only will refer to the entrenched articles.
You said the original Majes bill got amendments which you yourself concede one constitutional.
Yes, ma'am.
And this bill goes to second, third reading with adopted, and the bill passes into law with all those amendments, which would have required. So this continuum to want to separate the original bill, the amended bill, the bill was passed as one. It was passed as one bill, as one way along the way. That how could the signature of the president be severed to bring in? Please explain that to me. This, and if you look, let me give you an example. If you look at just when he's finally reporting report from the committee of the whole House, he says, "Madam Speaker, I beg to report that the committee of the whole House has considered the bill entitled the Constitution Amendment number 2 Bill 2017, and also introduced amending Article 179, 291, 105, and 260. Says, I beg to report. And this is adopted. And subsequently, the Speaker puts it to the vote that this do pass, the bill do pass, and the bill passes. So, where do you start truncating it?
My Lord, factually, that is what happened.
Yeah, I'm very
to the certificate of compliance that sent the bill to the president. The articles or the sections which offend these rules were not included.
And the Speaker
What went to the president?
and the Speaker was entitled to truncate it as the.
First of all, Honorable Kutana, I just seek clarification from you. Majezo reports to all, and this is adopted. It's adopted by the whole House and do pass into law. The bill goes for printing. The way I understand it, once Parliament has passed a matter, the bill must reflect what was passed by Parliament. I look at this bill and it seems somehow a reference to Article 260 was removed. It seems something was smuggled out, not in this time.
It's not there.
So I want to put this in the context of the ground you are talking about, conceptualized amendments. Those amendments, as passed by Parliament, must be reflected in the bill when it is final. The bill that is sent to the President, you look at it, I'm sure you have it there. Is there any reference to Article 260? And yet 260 was passed. It was passed. So that is one aspect that you need to explain. Now, as for what goes to the President, everything goes. Constitution, which has been passed in accordance with this chapter. Honorable Deputy Attorney General, we are together. a bill for the amendment of this Constitution, which has been passed in accordance with this chapter, shall be assented to by the President only if, that's the command of the Constitution, the President has no authority to assent to a bill unless the following happens. Only if it is that the provisions of this chapter have been complied with in relation to it. In relation to what? In relation to the bill. Now, what you are telling us, clauses, not all the required to sign it only if there is a certificate saying it complied with the Constitution. The law officers are here. If you had been called Honorable Attorney General by the President and said, this is what I have, would you have advised him to sign? Would you have advised the President to assent to that bill?
My Lords, I would advise the President to sign.
As far as I can see, the rationale for Article 263, to which I've just read out, is to make sure that if you are amending the Constitution, the things, and bring them into law.
My Lord, the bill doesn't contain any articles that were unconstitutional. That's Section 16 of the Acts of Parliament Act. In that act, which is on which is in volume 1 of our list of authorities, at page 8.
Well, you know, you have been going on and on, but just read it first so that we know what you're talking about.
Yeah, Section 16 says, bills amending the Constitution. Actually, that chapter, that part 5 says, certificates relating to bills amending the Constitution. 16 says, bills amending the Constitution. 16.2, the certificate required to be made by the Speaker of Parliament by Article 262 of the Constitution in respect to a bill passed in accordance with Article 259 of the Constitution shall be in the form specified in Part 6 of the second schedule. It's mandatory. Shall be in the form specified in Part 6 of the second schedule. When we go to the schedule,
I think the issue is what should be contained and what should not.
Yes, my Lord, that's what I'm going to. That form, read it as follows. Certificate, form of certificate of compliance with Articles 259 and 260. Then you put the year. Seeking to amend the Constitution being an article or articles referred to in Article 259 of the Constitution was on the dash day of this year and month, supported by so many members, reading on the second reading, and on the dash day of this, supported by so many members, at the time when the total membership of Parliament was this, to state the number, and the Constitution have been. My submission, my Lords, is that this form anticipates or reciting the Parliament.
No.
And
the bill that is being presented to the President first.
Yes, ma'am.
The Committee of the War House reported. And the chairman, the mover said, what my question was simple, and you have just answered it. You are the Attorney General of Uganda, you advise the President. He has a bill that came from Parliament, Constitution, right? And you say you would advise him to still go ahead and sign it. And the effect of it is that matters that they await a Constitution.
They are quite several.
The President is only supposed, the President is supposed to sign only if there is a certificate which says
No. My Lord, what went to the President was a bill containing all of those provisions that complied with the provisions of the Constitution.
So do you have a copy of the act which was passed?
They have put it here.
All right.
The next here contains all the
My Lords, the bill that went to the President contained all the provisions, including those which were amended.
Thank you. I think at this point we can adjourn. So we have given you an extra 15 minutes. We shall adjourn for just 15 minutes to come and listen to the last presentation from the Attorney General.